clerk will now proceed to read the orders of the day.
European Union Withdrawal Bill, second reading.
Thank you. Now, good indeed. That's helpful. I call to move the second reading of the Secretary of State for exiting the European Union, Secretary David Davis.
Thank you, Mr. Speaker. I was glad to hear the now. I was worried for a second. I beg to move that the bill be now read a second time. Mr. Speaker, when I introduced the European Union Notification of Withdrawal Bill earlier this year, I said that bill was just the beginning of a process to ensure the decision made by the people in June last year is honoured. And today we begin the next step in the historic process of honouring that decision. Put simply, this bill is an essential step. Whilst it does not take us out of the European Union, that's a matter for the Article 50 process, it does ensure that on the day we leave, businesses know where they stand, workers' rights are upheld, and consumers remain protected. This bill is vital to ensuring that as we leave, we do so in an orderly manner. Let me start with a brief summary of the bill before going on to set out its key provisions in more depth. The bill is designed to provide maximum possible legal certainty and continuity whilst restoring control to the United Kingdom. It does so in three broad steps. First, it removes from the statute book the key legislation passed by this Parliament in 1972, the European Communities Act. That Act gave European Union law supreme status over law made in this country. It is therefore right that it be removed from our statute book on the day the UK leaves the European Union, bringing to an end the supremacy of European law over laws made here in the United Kingdom. Second, the bill takes a snapshot of the body of EU law which currently forms part of the United Kingdom legal system and ensures that it will continue to apply in the United Kingdom after we leave. This is to ensure that wherever possible, the same rules and laws will apply the day after exit as they did before. Without this step, a large part of our law would fall away when the European Communities Act is repealed. But simply preserving European Union law is not enough. There will be many areas where the preserved law does not work as it should. So as its third key element, the bill provides ministers in this Parliament and in the devolved legislatures with powers to make statutory instruments to address the problems that would arise when we leave the European Union. These powers allow ministers to make those changes to ensure the statute book works on day one. This will be a major shared undertaking across the United Kingdom. In a moment. Well, I'll give way to both of them in a few minutes. Following this, it will be for the United Kingdom legislators to pass laws and for the United Kingdom courts to adjudicate those laws. Mr. Speaker, the bill enables us to leave the European Union in the smoothest and most orderly way possible. It's the most significant piece of legislation to be considered by this House for some time, and it will rightly be scrutinised clause by clause, line by line, on the floor of this House. And I stand ready to listen to those who offer improvements to the bill in the spirit of preparing our statute book for withdrawal from the European Union. The Right Honourable Member for Holborn and St Pancras likes to remind me of my past incarnation as a backbenchers champion and my dedication to holding the government to account. Mr. Speaker, I've not changed my views one jot. Let me be clear. This bill does only what is necessary for a smooth exit and to provide stability. However, as I have repeatedly said, I welcome and encourage contributions from those who approach the task in good faith and in a spirit of collaboration. All of us as legislators have a shared interest in making this bill a success and in the national interest. I give way to the honourable gentleman who rose first.
I'm very grateful to the Secretary of State for giving way. He mentioned in his opening remarks that the bill gives ministers the power to change laws through statutory instruments and in other mechanisms. Does that include changing laws to devolved administrations?
Well, I'll come to the detail of that later in this speech, in some detail, and how that process will work. So, if you'll be patient. The honourable gentleman second.
I thank the Secretary of State for giving way. Will he take this opportunity to confirm that the government will not use this bill to make policy changes?
Again, I'll detail it in some detail, but the primary aim of the bill, there's one exception to this, but the primary aim of the bill is to maintain policy as it is now. The only exception to that is under the withdrawal arrangements, and that will be time determined and limited. And I'll detail that again in a second. I'll give way one more time. There we are.
To the Secretary of State. George Osborne, in his headline in the Evening Standard last night, referred to the Secretary of State's approach as rule by decree. Why is the Secretary of State taking this high-handed approach to the practices of this Parliament?
Well, I don't read the Evening Standard, I have to tell you. And it sounds like with good reason. And I have to tell him that if I'm going to take lectures on rule by decree, it won't be from the editor of the Evening Standard. Now, the key point... One more time.
Right, honourable friend, confirm that if the government wishes to make a change by statutory instrument, that is a parliamentary process. It will be entirely in Parliament's control, and it's a synthetic nonsense to suggest that ministers are bypassing Parliament.
He's entirely right. It's a point I'll elaborate on later, and the editor of the Evening Standard should know that from his own experience. Now, the key point of this bill is to avoid significant and serious gaps in our statute book. The bill ensures consumers can be clear about their protections, employees can be clear about their rights, and businesses can be clear about the rules that regulate their trade. Workers' rights, consumer and environmental protections will be enforceable to the UK courts, which are renowned the world over. The bill provides certainty as to how the law applies after we leave the European Union, and ensures individuals and businesses can continue to find redress when problems arise. And in a moment, and of course, without this bill, all of these things are put at risk. The bill must be on the statute book in good time ahead of our withdrawal, so that the statutory instruments my right honourable friend referred to that will flow from the bill can be made in time for exit day. The House will have time to look at them, and so we are in a position to take control of our laws from day one. The bill provides a clear basis for our negotiation with the European Union by ensuring continuity and clarity in our laws, without prejudice to the ongoing negotiations. Without this legislation, a smooth and orderly exit is impossible. The shape of any interim period will need to be determined by the negotiations, but we cannot await the completion of negotiations before ensuring that there is legal certainty and continuity at the point of our exit. To do so will be reckless. The Honourable Lady was first, I think.
I thank the Secretary of State for giving way. Could he confirm his view that in choosing to not transpose the EU Charter of Fundamental Rights, that it will have no impact on the actual rights of the British people, their interpretation or their enforcement in the courts?
Well, if she remembers, I'm going to come again to this later, but if she remembers when the White Paper was presented to this House, I did actually say to her right honourable friend, my opposite number on the opposite benches, that if there were any powers that were missing, to come to the government, tell the House, and we will put that right. And that I haven't had a single comment since on that. So I'll make some progress now, and I'll give way a little later. I'm very conscious of the point that was made by the Father of the House that we are going to have tight time on this at least day, and I'll give way as much as reasonably, but I don't want to dilate too long. If you'll forgive me for the moment, Mr. Speaker, let me now talk the House through the bill's main provisions. The first clause of the bill repeals the European Communities Act on the day we leave the European Union, ending the supremacy of EU law in the UK and preventing new EU law from automatically flowing into UK law after that point. When the then Prime Minister Harold Wilson led a debate here in May 1967 on the question of the United Kingdom's entry into the European communities, he said, "It's important to realise that community law is mainly concerned with industrial and commercial activities with corporate bodies rather than private individuals. By far the greater part of our domestic law would remain unchanged after entry." I think the passage of time has shown that he was mistaken. European Union law touches on all aspects of our lives in a far wider way than the drafters of the European Communities Act could have envisaged. This means the bill we have before us today has a difficult task. It must rebuild United Kingdom law in a way that makes sense outside the European Union. in a moment. To do this, the first step the bill takes is to preserve all the domestic law we have made to implement our EU obligations. This mainly means preserving thousands of statutory instruments that have been made under the European Communities Act, with subjects ranging from aeroplane noise to zoo licensing. It also extends to preserving any other domestic law that fulfills our European Union obligations or otherwise relates to the European Union. In a moment, equally, the bill converts European Union law, principally EU regulations, all 12,000 of them, into domestic law on exit day. It also ensures that rights in the EU treaties that are directly effective, that's rights that are sufficiently clear, precise and unconditional they can be relied on in court by an individual, continue to be available in UK law under the bill. I've no doubt there is much about EU law that could be improved, and I know this Parliament will over time look to improve it. But that is not the purpose, including him, I think, the person who laughed just there. But that's not the purpose of this bill. This bill simply brings European Union law into UK law, ensuring that wherever possible the rules and laws are the same after exit as before. Just as important as the text of EU law is the interpretation of that law. For that reason, the bill ensures that any question as to the meaning of retained law is to be decided on in UK courts in accordance with the Court of Justice's case law and retain general principles of European Union law as they stood on exit day. This approach maximises stability by ensuring that the meaning of the law does not change overnight, and only the Supreme Court and the High Court of Justiciary in Scotland will be able to depart from retained EU case law. They will do so on the same basis they depart from their own case law. Any other approach would either actively cause uncertainty or fossilise EU case law forever. Future decisions of the Court of Justice will not bind our courts, but our courts will have discretion to have regard to such decisions if they consider it relevant and appropriate to do so, in just the same way that our courts might at the moment refer to cases in other common law jurisdictions such as Australia or Canada. The honourable gentleman's been patient.
I thank him for giving way. Given the scale of the task that he is setting out in his introduction to this bill and the huge impact that our relationship with the EU has on every aspect of our lives, our economy, our workers' rights, our environmental rights, our relationships on security and law, can he explain why we are only getting 8 days to discuss this bill in committee when the bill that took us in had 22 and the Maastricht Treaty had 20?
Well, the first thing I'd say to him, I mean, 8 days is quite a long time in this bill, but perhaps the most relevant comparison is the Lisbon Treaty, which actually recreated the European law on a major basis. This doesn't do that. This does not aim to change law, with a tiny exception, which I'll come back to. This does not aim to change law. This aims to maintain. It is primarily technical in that respect, and aims to maintain the laws that we currently have. And if he sees that as any different, then I will give way to it. I give way to the honourable gentleman.
Trouble with relying on secondary legislation is that secondary legislation is unamendable and only gets 1.5 hours debate. Would it not, in particular, in relation to any secondary legislation brought through under Section 9 of this bill, be sensible to allow a new form of secondary legislation where you can amend and you have substantial debate?
Well, in essence, the aim of the bill, remember, is to translate European Union law into UK law and to make sure that there are no problems arising, whether it means references to bodies that we no longer are subordinate to, whether it means the language is different, whether it applies to reciprocal rights. Many of this will be very straightforward and relatively simple. But the point you should look at in the legislation is that it seeks to make the type of secondary legislation, whether it's an affirmative or negative resolution, proportionate to that. If he wants to talk about this issue further, I'm happy to talk to him. I'm not going to reinvent the Constitution at this dispatch box. But I've said before, I'll happily give way. I'll give way here.
What conclusion should the electorate draw about respect from democracy from other parties' refusal to give this bill a second reading?
I'm not going to presume ill intent from the start. What I say to everybody in this House is the electorate will draw their own judgment I won't draw the judgment. The electorate will draw their own judgment as to whether people are addressing this in a sensible way to maintain the rights of British citizens and to maintain the continuity of British law in a way which will enable that to happen in good time for our departure from the Union, which is, after all, a fixed date, or whether they're simply using it as a cynical political exercise. It's not a decision for me to make. It is a decision for the electorate to make, and they make it, they will. Now, I will make some progress now. Overall then, not for a moment. Overall then, the bill provides, in a moment, overall then, the bill provides for a very significant continuity in the law. But there are some elements that simply, in a moment, that simply not make sense if they remain on the UK statute book once we have left the EU and in the years and decades to come. It would not make sense, for example, for the bill to preserve the supremacy of EU law, or to make the preserved EU law supreme over future legislation passed by this Parliament. Laws passed in these two houses after exit day will take precedence over retained EU law. Mr. Speaker, we also do not believe it will make sense to retain the Charter of Fundamental Rights. The Charter only applies to Member States when acting within the scope of EU law. We will not be a Member State, nor will be acting within the scope of EU law once we leave the European Union. As I said to the House when I published the White Paper on the bill, the Charter catalogues the rights found under EU law, which will be brought into UK law by the bill. It is not, and never was, the source of those rights. Those rights have their origins elsewhere in domestic law or relate to international treaties or obligations which the UK remains party to. For example, the ECHR. So let me be clear. The absence of the Charter will not affect the substantive rights available in the UK. And I've said, as dispatched before, as I said earlier, if members opposite or anyone in the House, and I'm thinking my right honourable friend, I'll come to him in a minute, anyone in this House find a substantive right that's not carried forward into UK law, they should say so, and we will deal with it. In the several months since I said that, no one has yet brought my attention to right we've missed. Now, it may be that will happen in the next 2 minutes, but I'll start with the Honourable Lady and then I'll come to my Honourable friend.
I thank the Secretary of State for giving way. He will know that the key issue is not what ministers say the aim of the bill is, but what the actual powers are that are contained in it. Yep. So can he tell the House what safeguards are there anywhere in the bill, in statute, that would prevent ministers in future using Clause 7 or Clause 9 or Clause 17 to completely rewrite extradition policy in the demise of the European arrest warrant without coming back to Parliament through primary legislation?
I'm going to come back to the details in a moment, but there are a number of limitations, one of which is that we cannot impinge on the Human Rights Act, which goes straight to the point that she was raising. I give way to my right honourable friend.
I'm most grateful to my right honourable friend for giving way. I understand his point about the Charter, because I agree with him that general principles in the Charter should be identical. Although that does suggest, one does raise the question as to why the Charter should go in those circumstances. But it says quite clearly in Schedule 1 that after this, we have done this, there is no right of action in domestic law on or after exit day based on a failure to comply with any of the general principles of EU law. He must agree that that means that the right of the individual to challenge on the basis that a principle of EU law imported into our law by this Act will no longer be possible. In our own courts, forget about the European Court of Justice, in our courts. And that seems to me to be a marked diminution in the rights of the individual and of corporate entities.
Well, I'm afraid we're going to have my old and dear right honourable friend are going to have a difference of opinion. We will, in fact, put in the library a letter on this specific issue, which we've already sent. But before we go there, the simple truth is that these laws, these rights, I should say, he should know as well as anybody. These rights originate from a whole series of origins. Some of them British common law, some of them EU law, which we'll bring in ourselves, some of them the European Convention on Human Rights, which you will note we are continuing with. So all of these things will provide those undertakings. Why on earth we need an extra layer of declaratory law, I do not know. It was brought in under the Blair government. Perhaps that explains why it was there. Now, Mr. Speaker. No, for the moment, in a moment. I will make some progress and I'll come back to the lady. Mr. Speaker, the conversion of EU law into UK law is an essential measure to ensure the UK leaves the EU in the smoothest way possible. However, that action alone is not enough to ensure that the statute book continues to function. Many laws will no longer make sense outside the EU. If we're only to convert EU law into UK law, our statute book would still be broken. Many laws would oblige UK individuals, firms or public authorities to continue to engage with the European Union in a way that's both absurd and impossible for a country that's not within the European Union. Other laws would leave the European Union institutions as key public authorities in the United Kingdom, a role they'd not be able to perform or fulfil. The problems which would arise without making these changes range from minor inconveniences to the disruption of vital services we all rely on every day. So in practical terms, this ranges from a public authority being required to submit reports on water quality to the European Union to actually causing disruption to the city by removing the supervision of credit rating agencies entirely. It's essential that these issues are addressed before we leave the European Union, or we'll be in breach of our duty as legislators to provide a functioning and clear set of laws for our citizens. That's why the bill provides a power to correct problems that arise in retained EU law as a result of our withdrawal from the European Union. This is Clause 7 of the bill, the so-called correcting power. Now, unlike Section 2.2, and this goes straight to the point the Right Honourable Lady raised, unlike Section 2.2 of the European Communities Act, which can be used to do almost anything to the statute book to implement EU law, the correcting power is a limited power. It can only be used to correct problems with the statute book arising directly from our withdrawal from the European Union. Ministers cannot use it simply to replace European Union laws they do not like. It's designed to allow us to replicate as closely as possible existing European Union laws and regimes in a domestic context. It's also restricted so it cannot, for example, be used to create serious criminal offences, amend the Human Rights Act, impose or increase taxation. And we've ensured that it expires 2 years after exit day so that nobody can suggest there's an attempt at a permanent attempt to transfer power to the executive. Mr. Speaker, I accept that proposing a delegated power of this breadth is unusual. But leaving the European Union presents us with a unique set of challenges that need a pragmatic solution. Using secondary legislation to tackle challenges such as these is not unusual. Secondary legislation is a process of long standing with clear and established roles for Parliament. The Honourable Lady.
Very, very grateful to the Secretary of State for giving way. Following on from the point made by the Right Honourable Member for Beaconsfield, the Secretary of State has asked for concrete examples of rights that will be lost to UK citizens as a result of this Act. So I'd like to give him one and ask for his undertaking that he will amend the Act to make sure this right won't be lost. Earlier this summer, a man called John Walker relied on EU equality law to bring his successful challenge to a loophole in UK law that meant employers could refuse to pay same-sex partners the same pensions benefits as heterosexual couples if the funds were paid in before December 2005. And the Supreme Court, our Supreme Court, not the European Court of Justice, agreed that there was a loophole in UK law which was a violation of the general principles of non-discrimination in EU law. So Mr Walker was able to use his right of action under the general principles of EU law to close that loophole so that he and his husband can enjoy the same rights as a heterosexual couple. That wouldn't be possible under this bill because, as the Right Honourable gentleman said...
Order. This is a very lawyerly intervention, which is not altogether surprising in view of its genesis. But I'm looking for the question mark.
I'm coming to the question, but the Minister asked for examples. This wouldn't be possible under this bill because there's no right to sue. Will he give an undertaking that he will close this loophole in the bill if we bring forward an appropriate amendment?
I think that will be brought forward in the course of the bill's translation. But if not, I know I'm standing exactly by my undertaking. If not, she should come to me, and we will find a way of correcting that problem. Now, with respect, we've had one lengthy intervention. I've got to make some progress. Now, our current estimate is that the UK government will need to make between 800 and 1,000 statutory instruments to make exit a reality in UK law. Mr. Speaker, This may seem in some ways like a large number. It's a little less than 1 year's quota, as it were. And I understand members have concerns about the scrutiny of this volume of legislation. But let me contrast this to the 12,000 European Union regulations and 8,000 domestic regulations, 20,000 pieces of law that have brought forward new policies while we have been members of the European Union. This one-off task is very different to the flow of new law we've had from the European Union in the last 40 years, and is ultimately about ensuring that power returns to this House. The people who complain about using secondary legislation should remember, of that 20,000 pieces of law, 8,000 of them went through under secondary legislation. The remaining 12,000 went through without any involvement from this House at all, because they came as regulations. And they were changing the law rather than maintaining the law. Now, all of these changes must happen quickly to maintain stability as we leave the European Union. Many of the changes will be minor and technical, replacing, for example, references to European Union law or to other member states. It would not make sense, nor would it be possible, to make these numerous changes in primary legislation. Some of the changes we bring forward will, by their nature, be more substantial and will demand more scrutiny. An example will be a proposal to transfer a function currently exercised by the Commission to a new domestic body that needs to be set up from scratch. Now, we hope to minimise the need for such bodies, but where they are needed, I readily accept that these changes require fuller parliamentary scrutiny. That's why the bill sets clear criteria that will trigger the use of the affirmative procedure, ensuring debate and vote on the instrument in both houses. Over the course of the 2 days we'll spend debating this bill, I'm sure we'll hear calls for the secondary legislation to receive greater scrutiny. If you give way for a minute. I'm sure she'll hear calls for this secondary legislation to receive greater scrutiny, which the honourable gentleman has already made, along the lines given to primary legislation. Now, I say to honourable members that I'm clear that the way to make significant changes is through primary legislation, significant changes. That's why the Queen's speech set out plans for several further bills to follow this one, including on immigration, trade and sanctions. Bringing in significant new policy changes is not the task at hand. With this power, we are making corrections to the statute book rather than bringing in new policies that take advantages of the opportunities offered by a withdrawal from the EU. Now, second, these corrections need to be made to ensure we have a functioning statute book. As far as we can see, the power we have proposed is the only logical and feasible way to make those corrections. Our approach remains the only viable plan. We considered others put forward in this House. While we've heard complaints from the benches opposite, we have not seen any alternative. The honourable gentleman was individual.
Secretary of State for giving way. The central premise of what he's argued this morning is that in order to ensure a smooth exit, we need to maintain as much of the status quo as possible on the way out. But this bill goes much further, because looking at Clause 5 and Clause 6, those changes contained within would effectively rule out being within the customs union and the single market for a transitional period. That is the single biggest risk to our economy, and that is what is contained in this bill.
Well, he is quite right in one respect. That is clear government policy. That is, in fact, what the decision was taken by the British people last year was, that they wanted to leave the European Union, which means leaving the single market and leaving the customs union. That point is clear. I know it's confusing on that side of the House, because the Deputy Leader of the Labour Party appears to have a different view to the rest of the Labour Party. But let me make some further progress after that rather silly intervention. Mr. Speaker, the bill also contains a limited power to implement the withdrawal agreement by statutory instrument if that proves necessary. In a moment, the government's aspiration is to agree a new deep and special partnership with the European Union. Under the Article 50 process, and we are negotiating withdrawal agreement with the European Union. Provisions of that agreement will need to be implemented in domestic law, and some of that will need to be done by exit day. In a moment, given the timetable set by Article 50, it's prudent to take this power now so that we're ready, if necessary, to move quickly to implement aspects of an agreement in domestic law. This will be particularly important if the negotiations conclude late in the 2-year period. This power will help to ensure that the UK Government and devolved administrations are able to implement the outcome of the negotiations. The power is limited. It will only be available until exit day, at which point it will expire. The power is aimed at making the legislative changes that absolutely need to be in place for day one of exit to enable an orderly withdrawal from the European Union. The Honourable Lady, I think, has
waited I've listened very, very patiently to the Secretary of State, who is waxed lyrical about these regulations and delegated legislation. It's just standard. It's not just standard. I'd like the Secretary of State to say something about the status of this delegated legislation made under Clause 7. It gives it the status of an Act of Parliament. This is an attempt to oust review by the Court. I'd like him to elaborate upon that very, very important issue.
I'm afraid it's not correct, and this point was made actually by another member. It may even have been the Honourable Gentleman trying to intervene at the moment, about the ability to change bits of primary legislation. And the simple truth is that that's a fairly standard set of words used in these legislation. Now, the 2002 Enterprise Act has it in, the 2010 Third Parties Act, both Labour Party acts, and it's the normal routine because you want to make sure that nothing in the bill prevents the ability to go into a transition phase, for example, and into the next phase of negotiation. Now, the exact, forgive me, I'll make some progress. The exact use of the power will, of course, depend on the contents of the withdrawal agreement. For example, a power could, depending on what the withdrawal agreement says, be used to clarify the status of UK cases at the CJEU that started before exit but were not yet concluded on exit day. It could also be used, for example, to enable regulatory approvals for UK products that were pending at the point of exit, in line with the proposals set out in the UK's position paper on continuity of availability of goods in the EU and the UK this summer. Those sorts of fairly technical but important issues need to be capable of being changed. I'll give way in 1 second to my honourable friend. We have already committed to bringing forward a motion on the final agreement to be approved by both Houses of Parliament before it's concluded. That vote is in addition to the Parliament's scrutiny of any statutory instruments that we propose under this power, and also in addition to the enormous amount of debate and scrutiny that will be applied to the primary legislation that will cover all and every major policy change around our exit from the European Union. So Parliament will be fully involved in taking forward a withdrawal agreement. I give way to my honourable friend.
One of the most offensive kinds of provision that appear in our domestic legislation is the Henry VIII clause, as we call it. Not my words, but the very wise words of my right honourable friend, the member for Stone, in 2013. So there have been long-standing real concerns about statutory instruments for many years right across these benches. So to allay those concerns, would my right honourable friend look at what is called a triaging of these proposed statutory instruments? Many thousands will be completely uncontroversial and can be dealt with very quickly and efficiently. But those which really must be considered fully by this chamber in this place could then happen if we have this triaging. Would my right honourable friend please agree to look at that principle? It will solve many of the difficulties with this bill across all these benches.
I thank my right honourable friend for her suggestion. It won't be many thousands. It's between 800 to 1,000 as the estimates come down from several thousand, because we've taken up much of the most serious legislation in primary legislation, other primary legislation. But I'll happily talk to her about mechanisms for making sure this is a fully democratic and open process, and so I will talk to her about that. And let's come back to it. Well, talk to her about it in the bill process, and talk to her about it possibly changing. No, forgive me, I'm trying to hold back on too many interventions, but I will discuss it with her, and we'll look at possible amendments. Now, I will give way to the chairman of the
State for giving way. On the powers in Clause 9 to implement the withdrawal agreement, is the Secretary of State able to give the House an assurance that those powers will not be exercised until Parliament has had an opportunity to vote on the agreement?
To vote on the agreement. On the agreement, I'm just thinking through the logic of that. It seems to me logical, in truth. I will, if you'll allow me a few moments to review the matter. It seems to me perfectly possible I could give that and take it, but I won't do it just on the fly in case I've missed something. He's right. No. He's right. He's right. Let me say to the House, he's right about one thing, in that there is the two issues run together. the question of the overall judgment on the outcome and any withdrawal arrangements. Now, the withdrawal arrangements are most likely to come up if it arrives late, and that's why I've got to think through what the possible timetables are. You will remember when we talked about how the House will be able to review the negotiated agreement, that we said we would make best endeavours. We intend and expect that we get it to the House before anybody else does that. That's what we intend. But we had to use that form of words because we weren't sure about timing. But I will talk to him and I will come back to him on that matter. Now, Mr. Speaker, I want to move on to another subject, if I may, which is the question of devolution. It relates directly to some of the things the opposition have been saying. Let me now deal with the bill's approach to devolution. As I set out, the overall approach of this bill is to provide for continuity wherever possible at the point of exit, not seek to initiate reforms immediately. That is the approach that guides the devolution provisions as well. Now, let me be clear. This government has a strong track record of devolution. Our commitment to strengthen devolution settlements is clear from the statute book, most recently the Wales Act 2017 and the Scotland Act 2016. Which, if I remember correctly, gave something like 12 billion of tax-raising powers to the Scottish Parliament. So not such small things. Leaving the European Union allows us to make sure that decision-making sits closer to the people than ever before. We expect a significant increase in the decision-making power of the devolved institutions. The current devolution... The current devolution settlements have always created common frameworks within the United Kingdom by reflecting the context of the UK's EU membership. So in areas subject to European Union law, all parts of the United Kingdom currently follow common rules and principles, even where matters are otherwise devolved. For example, England, Wales, Scotland and Northern Ireland each pass their own laws relating to food policy, but each nation has to ensure they comply with European Union rules on food hygiene. When we leave the European Union, it's not in the interests of people and businesses living and working across the UK for all those arrangements to disappear, or for there to be new barriers to living and doing business within our own country. In a second. So the bill provides certainty and continuity for people across the UK by recreating in UK law the common frameworks currently provided by EU law and providing that the devolved institutions cannot generally modify them. The bill also ensures that every decision that the devolved administrations and legislatures could take before exit day, they can still take after exit day. Mr. Speaker, this is a transitional arrangement. It's an arrangement that ensures certainty and continuity whilst the United Kingdom undertakes negotiations with the European Union on its future relationship, and the UK government and devolved administrations discuss precisely where we need to retain common frameworks within the United Kingdom in the future. I give way to the Honourable Gentleman.
The right honourable gentleman for giving way. What he's therefore describing is not devolution, it's reserving powers back to this Parliament. It's a fundamental breach of the principles of the original Scotland Act. Can he confirm that any statutory instruments, or can he tell us whether or not any statutory instruments that go through this House that affect the devolved administrations will be, as a result of this bill, will be subject to legislative consent in those administrations?
I have said already that we will be putting our overall negotiation through legislative consent motion. That point I made before. But let's just come back to the core of this argument. The argument put here is that everything that belongs to the European Union now belongs to the devolved administrations. Now, this clearly doesn't work, as we'll come to in a minute. These common frameworks will be important, as they will enable us to manage shared resources, such as the sea, rivers, the air, and enable the continued functioning of the UK's internal market. They will allow us to strike ambitious trade deals, administer and provide access to justice in cases of a cross-border element, and enter into new international treaties. And this includes, indeed, our future relationship with the European Union. Not for the moment. No, not for the moment. For example, they'll mean a business in Wales knows it only needs to comply with one set of rules on food labelling and safety in order to sell to the rest of the United Kingdom. Or that a farmer in Scotland is able to sell her livestock in other parts of Great Britain, safe in the knowledge that the same animal health rules apply across that geographic area. Certainty on common approaches is critical. Certainty on common approaches is critical for the day-to-day life of people in the United Kingdom on the day we exit the European Union and into the future. The honourable gentleman was trying to get in on me. Sorry.
I mean, if this is a smooth transition, I'm not sure how much worse it's going to get, Mr. Speaker. But on the points he raises, and he's making a very good case for the European Union,
Yes.
I don't see any reference in here to the immigration powers that Scotland was promised during the referendum process. Can you maybe explain?
I don't remember any such promise. But what was interesting? In this, when I was going through the lists of practical things that apply to the citizens that they are supposed to represent, what do we hear? Wow, they don't care. What they're interested in is devolution and political power for themselves, not the interests of their own constituents. So, just as important are those areas where we do not need common approaches in the future. We do not expect we'll need to maintain a framework in every single area the EU has mandated. We can ensure our common approaches are better suited to the UK and our devolution settlements, and therefore the bill provides a mechanism to release policy areas where no frameworks are needed. This bill gives time for us to work together with the devolved administrations to determine where we will continue to need common frameworks in future. And crucially, it will not create unnecessary short-term change that negatively affects people or businesses. Before the summer recess, my right honourable friend, the First Secretary of State, wrote to the Scottish and Welsh governments to begin intensive discussions about where common frameworks are and are not needed. In the current absence of Northern Ireland Executive, equivalent engagement has taken place at official level with the Northern Ireland Civil Service. We will bring forward further detail on the process underpinning these discussions in due course for Parliament to decide. Certainly not for the moment. Certainly in devolved legislation affected by the EU exit, certainty is also vitally important. The key delegated powers in this bill are conferred on the devolved administrations so that the task of preparing the devolved statute books for exit can rightly be led from Scotland, Wales and Northern Ireland. The Government is committed to ensuring the powers work for the administrations and legislatures. For instance, I've already confirmed we will always consult the administrations on corrections made to direct EU law that relate to otherwise devolved areas of competence. I firmly believe that the outcome of this process will be a significant increase in decision-making power of each devolved administration and legislature. It will mean that decisions and power, not for the moment, and power sit in the right place and closer to people than ever before. And crucially, this bill means our UK businesses and citizens have confidence and certainty in the laws that allow them to live and operate across the UK as we exit the European Union. Now, as the Prime Minister said... I've given way to her once. As the Prime Minister said in January... I'm coming to the end of my comments. As the Prime Minister said in January, the historic decision taken by the British people in June last year was not a rejection of the common values and history that we share with the European Union. But it was a reflection of the desire of British people to control our own laws and ensure these reflect the country and the people we want to be. This bill is an essential building block for this. It lays the foundation for a functioning statute book which future policies and laws can be debated and altered. This bill is itself not the place for those substantive changes to the frameworks we inherit from the EU. We will have many more opportunities to debate those both before and after we leave. Now, I hope honourable members on all sides will recognise that we've acted responsibly in leaving the EU by prioritising, first and foremost, a functioning statute book. In bringing forward this bill, we are ensuring the smoothest possible exit from the European Union, an exit that enables a continued stability of the UK's legal system and maximises certainty for businesses, consumers and individuals across the UK. And as we exit the EU and seek a new, deep and special partnership with the European Union, the bill ensures that we will be doing so from a position where we have the same standards and rules. So in this bill, we're not rejecting EU law, but embracing the work done between Member States over 40 years of membership and using that solid foundation to build on the future once we return to being masters of our own laws. I hope everyone in this House recognises this bill's essential nature. It's a foundation upon which we will legislate for years. Now, we've just had this morning the proposals from the opposition on their proposal to move a reasoned amendment. I've just emphasised the critical nature of this bill. A vote for the Honourable Member's amendment is a vote against this bill. A vote for a chaotic exit from the European Union. The amendment suggests The amendment suggests that this bill provides some sort of blank cheque to ministers. That's a fundamental misrepresentation of Parliament and our democratic process. Using the bill's powers does not mean avoiding parliamentary scrutiny. Secondary legislation is still subject to parliamentary oversight, using well-established procedures. In no way provides unchecked unilateral powers to the government. On rights, the government agrees that EU exit cannot and will not lead to weaker rights and protections in the UK, as I've just said to the Honourable Lady. We have been clear we want to ensure workers' rights are protected and enhanced as we leave the European Union. This bill provides for existing legislation in this area to be retained. After we leave the EU, it will be for Parliament to determine the proper level of rights protection. On devolution, I've just gone in detail through how we're going to deal with that. And finally, the argument that this bill undermines any particular approach to interim or transitional period for the implementation of our new arrangements with the EU is completely wrong. The bill provides a clear basis for our negotiation by ensuring continuity and clarity in our laws, without prejudice to the ongoing negotiations. Without this legislation, a smooth and orderly exit is impossible. We cannot await the completion of negotiations before ensuring there's legal certainty and continuity at the point of our exit. To do so, or to delay or oppose the bill will be reckless in the extreme. Mr. Speaker, I have in the past witnessed the Labour Party on European business take the most cynical, unprincipled approach to legislation that I have ever seen. They are now attempting to do the same today, and the British people will not forgive them if the end of their process is to delay or destroy the process by which we leave the European Union.
Order. The question is that the bill be now read a second time.